coming up.
The Vercheron Center got $2 million from the industry department. Then it got another $2.2 million from, I believe it was ACOA, and then another $1 million from ACOA. And it goes on and on over the next couple months, $1.4 million from DFO, for a total of almost $10 million. So did your team help secure the ISED or ACOA money in terms of directing them for the Vercheron Center when it couldn't get it from STDC?
So prior to your appearances today, did you receive any briefings from any other member at STDC, the NRC, the Minister of ISED, any of his deputies or assistant deputies, or anyone in the Privy Council office or the PMO office?
This is an organization that is riddled with conflicts, so many conflicts that within hours of the Auditor General's report, the minister shut down STDC. Do you not see the conflict or the perception of a conflict with what you wrote when you said, we're going to help you even though we're conflicted to actually fund you directly? We're going to do indirectly what we can't do directly?
Could you tell me who in the Privy, as a recipient, your office as a recipient of that direction from the Privy Council office, who in the Privy Council office wrote that letter?
A refusal to answer can constitute a contempt of Parliament. So I'm going to give you one more opportunity to answer a very simple question. Have there been conversations, yes or no, regarding severance or exit packages for executives at STDC? It's a yes or no question. You're required to answer.
But the fact of the matter remains, despite the best efforts of Mr. Erskine Smith, the RCMP have confirmed an ongoing investigation.
For the record, to be clear, you're not a lawyer, police investigator, or an expert to determine whether there was a conspiracy to commit fraud or those types of matters, correct?
You're correct. I am a CPA.
This Guy's Garage. Like and subscribe.
The Vercheron Center, which is a center that Annette Vercheron set up at Cape Breton University, applied while Annette Vercheron was chair for, I believe, almost a total of $6.8 million through various STDC funds, and that consideration came to the investment committee, I believe, which you oversaw. Is that correct?
Mr. Chair, this project was never approved or even considered by the Project Review Committee. The company had applied and routine due diligence was conducted, but upon being made aware that STDC staff had conducted due diligence on this application, the PRC removed the project from any further consideration.
So on July 30th, 2021, you wrote in an email to your team, to someone named Jen, that you were fast-tracking the approval of that. What did that email mean?
Mr. Chair?
Jen, I think she was the applications lead.
That's correct. So this project applied via the standard application process. The fast-tracking you are referring to occurs when we have sufficient information regarding any application to move to the second step or the third step in our comprehensive six-step due diligence process. In this particular case, while I don't recall the exact details, if it was approved for fast track, that means it would meet that criteria. In general, in our process, probably about 10% of the projects that do apply would receive this fast track consideration.
So I appreciate that. Thank you. Did Ms. Vercheron call and inquire at any point of time onto the status of that application?
Mr. Chair, Ms. Vercheron never did ever call to inquire about that application.
On January 18th, 2022, you wrote that while the application would not proceed, that SDTC would give its best efforts to find the Vercheron Center money elsewhere in the government. Is that correct?
Mr. Chair, while I don't recall the exact nature of that email or recall that email, what I can say is it is common practice at SDTC where we will, if there is not a fit for funding within the SDTC programming, we have a variety of federal and provincial partnerships. And given the work that we would have done, for example, on an application and all the diligence, we do try and pass that off to other agencies, potentially where there might be a better fit. We don't try and influence those decisions. It's really more a question of can we convey what we have learned and pass that off for others for potential consideration.
So in essence, you act as a business development arm to find other government money for projects, including one named after the family of the chair of the board. On June 9th, 2022, a few months after that letter, the Vercheron Center got $2 million from the industry department. Then it got another $2.2 million from, I believe it was ACOA, and then another $1 million from ACOA. And it goes on and on over the next couple of months, $1.4 million from DFO, for a total of almost $10 million. So did your team help secure the ISED or ACOA money in terms of directing them for the Vercheron Center when it couldn't get it from SDTC?
Mr. Chair, my recollection after would have been maybe after the initial round of introductions. I don't recall or remember us participating in any diligence by these other agencies. But to be fully, I'd have to look into it to confirm that. But that is my recollection.
But you did commit, as you said was your standard practice, to help them, and then suddenly they, over the next couple of months, got shockingly money from the ISED department where SDTC reported to that minister, and also got money from ACOA, which also falls under the industry department. So I think actually it was a pretty good, in my view, bailout to get free business development, government granting money for an entity that was set up by the chair, that then went and got money, actually more money than it was seeking from SDTC in the next few months from other departments. Did SDTC charge the Vercheron Center for any of those services?
Mr. Chair, as I previously just said, as a standard practice, we do try and engage in referrals to other agencies. It goes both ways. We also work actively, for example, with the Clean Growth Hub, and we receive many referrals from other funding programs. We offer this as a service for applicants in terms of trying to help them as much as we can with those particular referrals.
Thank you. That concludes your round, Mr. Perkins. Turning on to Ms. Brad.
So I'd like to discuss the House motion with you that was passed on June the 10th, 2024. You've raised serious alarm bells regarding their extent and scope and how it risks compromising your office's independence. Could you please speak to your concerns?
Absolutely. I guess I would start by saying that I am not questioning the privilege of the House of Commons to order the production of documents, and that my office, as I stated in my letter, will produce documents, and we have already started to produce some of those. I guess fundamentally the documents that are being sought are really belong to the departments or to the foundation. So they belong to a third party. And they need to decide if they will produce those documents before I can produce those documents. It's kind of like being a caboose on a train because they are the owners of the information. I need to see what they will do with the owners, with their information. I think there is this ongoing dispute between the government and Parliament over the documents, and I should not become a mechanism by which Parliament receives government information. So I believe that my independence would be compromised if I become that vehicle. And then there is also the unintended consequence that this could sort of put a chilling effect on departments and agencies sharing free and unfettered information with my office. I do have very broad access to information, and I need to preserve that broad access.
Largely, my questions in this particular round will be directed to you, Mr. Rami. Prior to your attendance today, actually, before I get to that, is this the first time that you've appeared at committee to discuss the STDC?
That is correct.
Yes. So prior to your appearance today, did you receive any briefings from any other member at STDC, the NRC, the Minister of ISED, any of his deputies or assistant deputies, or anyone in the Privy Council office or the PMO office?
Mr. Chair, I just want to clarify briefings. What type of briefings?
To prepare you for this hearing.
Thank you. Mr. Chair, I would have certainly have received briefings from my colleagues at STDC. I would not have received any briefings whatsoever from, to go through the rest of your list, the NRC, anybody from the ministry, or did you say the deputy minister, or any other ISED officials?
Okay, so strictly from STDC only?
That is correct.
Okay. In response to one of the questions put to you by my colleague, Mr. Perkins, in the first round, I saw you deliberately looking down and reading from what appears to be notes or a document. Is that accurate?
I do have notes that I prepared for myself.
Okay. We would like you to table those notes to this committee. Is that something that you'd be prepared to do?
I will look into that for you.
Chair?
Just one sec, please. Hold on a second. Mr. Brock, I'm going to let you continue, and I'm going to come back to you on that, please.
Were these notes prepared by you or any other member of STDC?
Mr. Chair, these notes would have been prepared by my colleagues at STDC, and I would have certainly had some input and contributed to that.
Who are the colleagues?
Mr. Chair, sorry, I'll have to, what's the question, sorry?
Who were the colleagues?
They were colleagues, the colleagues who've been monitoring the hearings that have been ongoing related to STDC.
I'd like the names, sir. I would like the names and the official title of all those individuals who've been monitoring these hearings and giving you advice and or speaking notes in relation to your appearance today. Is that something that you'll comply with?
I will look into that, Mr. Chair.
You indicated in your opening statement part of your role as COO is to implement recommendations of the AG report. One of those recommendations of the AG report is to recover monies that were inappropriately taken from taxpayers. We have approximately $400 million identified as misuse taxpayer funds that went to Liberal insiders. A couple of months ago, we heard from one of the current acting directors, Cassie Doyle. I put to her several questions, as did other members put to her several questions as to when taxpayers will receive their money back, and she refused to give us a straight answer. It is something I know that the Auditor General is quite concerned about. When she testified back in June of this year, there was no clear indication from the government as to what the timetable was. So I'm asking you, sir, as the COO, what is the plan and what is the process, and when can Canadians expect to receive their hard-earned tax dollars back?
Mr. Chair, Of the 11 Auditor General recommendations, 10 have been implemented. There is one that is ongoing related to a very specific recommendation around reviewing the eligibility of all projects that were covered in the sample period that was covered by the Auditor General in her team.
Sir, I'm not asking about the process. I'm asking about when will you answer a question, or a member of your team answer a question, as to what the process is to repay the taxpayer. When can we expect this?
And Mr. Chair, just to continue, in that plan we tabled back in June, the eligibility review is targeted to be completed by the end of December.
Who's doing
Thank
that
you.
review?
Mr. Brock, I'm afraid that is the time. We will certainly come back to you.
Can we come back to the questions I put to this particular witness?
Yeah, so Mr. Rami, the question has been put forward. I think it kind of breaks down into two parts. If you would perhaps, if you would provide to this committee, as Mr. Brock recommended, the name of the officials that provided briefings to you would be appreciated. I don't think there's anything too out of sorts with that request. As for your notes, if you would provide us both the notes that you're prepared to provide and as well make very clear parts that you are not. And I would urge you to be as forthcoming as possible. So because this, and again, we're not here yet. The committee, I'll just remind you, the committee does have the ability to order the production of documents. So I would urge you to be as forthcoming as possible, and we look for that information in the next 3 weeks. Could I leave that with you? Is that because I realize those are notes prepared for yourself, but they could well be relevant. So, and I think there's a point of order for Mr. Durian. Yes, Mr. Durian.
Just on that, are we advising the witnesses that are appearing here that their personal notes may be shared? So I'm just wondering, is Mr. Brock interested in the doodles that the witness may have done, or is he interested? Like, I'm just wondering, are we giving them a warning that their notes may be shared? Just because if I was appearing as a witness, I would like to know that.
Sure. Well, I think as you know, Mr. Durian, the committee does have, as does Parliament, latitude to order the production of documents. In this case, they have been requested. This is something that I had not heard of before, which is why I wanted to consult with the clerk here and find a path forward that would be appropriate. And I think we've landed there. So if that's, I'm going to turn things over to Ms. Khalid. You have the floor. Yes, Ms. Khalid. So is it point of order?
Yes,
Yes, go
just
ahead.
on that same one, I think it is reasonable for us to, whatever documents the witness provides, for us to be able to review them in camera, and then as a committee decide whether they should be made public or not.
We could do that.
To respect
Sure.
the reasonable privacy of any
Sure.
witness and not set precedents.
Just 1 second, Mr. McCauley. Yes.
On that point, like under the Access Information Act, his notes are atypical, so they are not private. They would, I could file a tip right today on Mr. Rami and receive those handwritten notes. That's required under the Access Information Act. He works for the government. Those notes written are therefore part of the public record. So that there's no
Yes, Ms. Khalid.
privacy on this.
I do believe there are exemptions, and that rule is not a complete blanket to get access to somebody's doodles. So I do think that we need to proceed with caution. Absolutely agree that if the witness wants to
Order. Ms. Khalid, you have the floor. Yes.
I try not to heckle my colleagues on a regular basis,
You-
Chair, although I have
attention,
lots of
yes.
heckles to do, but I try to be respectful, and I would obviously appreciate the same courtesy. What I was trying to say is that I think it is important for us to, as a committee, review the notes in camera before we decide whether or not to make them public.
I'm prepared to allow that, but I would just signal to the witness, you should send us your notes as if you expect they would be public, please. And again, I would ask that you be clear if you've removed elements and why that is. On that note, I'm going to move on. Ms. Khalid, you have the floor for 5 minutes, please.
Thank you very much, Chair. To Ms. Hogan, welcome back to our committee and to your team. I know how hard you work. Just off the bat, Ms. Hogan, what is your security clearance level?
Top secret.
And has that security clearance level ever stopped you from producing the amazing reports that you provide and highlighting the important issues that you provide to our country?
Yes, it would. It would restrict what I could put in a public report. Yes.
And what kind of restrictions are those? Does that stop you from highlighting important issues?
So, no, it doesn't stop me from highlighting important issues, but it stops me from providing maybe the level of detail that some members of Parliament would perhaps prefer, because I do have to protect information that should not be in the public domain.
Why is that? Why do you have to protect that information?
So having a security clearance is a privilege, and things are classified either because they could harm an individual or they could harm the national interest. So there's sort of two levels, and it is my responsibility as a public servant to respect that and not to bring unnecessary harm either to the country, our national interests, or to a Canadian citizen.
I appreciate that, but just to confirm, your security clearance level does not stop you from doing the work that your office is designed to do as an independent office, correct?
Correct. Not everyone in my organization has top secret. Not everyone needs that level of security. And so we do ensure that when that kind of information is part of an audit, that those who have the appropriate security clearance are only allowed to view it. And we do so in a very secure fashion. But it doesn't stop me from doing my work. It impacts what I can publicly report.
Thank you. So just on that, now your office has the ability to provide evidence to the RCMP in the case of any criminality. Is that correct?
In order to do so, the established mechanism that we have with the RCMP is that a production order is provided. We do have some informal and general conversations before that might happen, but that is typically the course of action.
So as of July 25th, the RCMP had confirmed that they hadn't received any request or any such order from your office. Is that also correct?
So the order comes the other way. The RCMP sends me a production order if they want information, but we have, as I mentioned earlier, have a good working relationship with the RCMP, and we do let them know when we're embarking on work and when our work is going to be made public, unless we feel it necessary to refer something to them before the report is made public. But that happens in rare instances. We usually speak to them after our report is public if we feel they should be involved.
Mr. Rami, on January 18th, 2022, you wrote to the Vercheron Center in which you stated that STDC would, quote, give best efforts to help the Vercheron Center secure funding. The whistleblower stated in his testimony that unprecedented efforts were made by employees using STDC's reputation to help secure funding for the Vercheron Center. And we know that not long after you indicated that STDC would undertake its best efforts to assist, that the Vercheron Center received $10 million, or nearly $10 million in funding from ICED and ACOA. So how is it possible that you thought it was appropriate to use taxpayer-funded resources at STDC to help secure funding for the chair's personal vanity project?
Mr. Chair, as I would have previously said, we do have a common practice for applicants who don't make it through our own process. We try and refer them to other funding programs, whether federal or provincial, and we try and assist in that referral process. I don't recall the specifics. My recollection.
Well, sir,
is
with the greatest, Mr. Rami, I appreciate that there is a general practice or a general process, but this was not a normal application. It was an application from the Vercheron Center named in the name of the chair. It was her vanity project. She served as a director. Staff flagged the funding request for $6.8 million from STDC to be in a conflict. So if that's a conflict, isn't it also a conflict or gives rise to the perception of a conflict for STDC to say, well, we can't fund you directly, but we're going to be the agent of the Vercheron Center to help secure funding from other government departments and agencies?
Mr. Chair, again, we assisted with referrals. Once those referrals were done, my recollection is we were no longer involved in any other application or diligence or whatever it may have been.
The whistleblower said that unprecedented efforts were taken to help secure funding, and that would be supported by the fact that you confirmed that STDC did provide assistance, and then, just by coincidence, $10 million arrived at the Vercheron Center from none other than the Department of Industry, from none other than ACOA, which also STDC, just by coincidence, falls under that department as well. So are you disputing what the whistleblower stated in his testimony?
Mr. Chair, just to repeat what I've said, we have a referral process. Once that referral is done, we're not involved in any of the decisions.
I don't understand, and I would like you to explain, because you wrote the letter that if there's a conflict of interest to fund the project because it's the chair's vanity project, wouldn't the obvious thing to do to walk away entirely from the Vercheron Center, as opposed to saying we're going to take our best efforts and then direct staff to assist in helping secure funding to that project?
Again, Mr. Chair, to repeat my answer,
do you not see the conflict? Do you not see the perception of a conflict? I mean, this is an organization that is riddled with conflicts, so many conflicts that within hours of the Auditor General's report, the minister shut down STDC. Do you not see the conflict or the perception of a conflict with what you wrote when you said, we're going to help you even though we're conflicted to actually fund you directly? We're going to do indirectly what we can't do directly?
Mr. Chair, our role wasn't to provide funding. We provided
but to act as an agent of Annette Vercheron's vanity project, after which she got $10 million from the very same department that STDC fell under industry.
No, again, Mr. Chair, to repeat my answer, we weren't involved in the decision making at all. We wouldn't participate in that.
So you don't see a conflict. No wonder this is such a mess. It's all about helping insiders at STDC will leave the room and get funding for a company. Well, we can't fund the chair's accelerator directly, but we'll go around and we'll help them behind the scenes. And
thank you,
it's really
Mr.
unacceptable.
Cooper. And to finish up this round, and then we'll have a recess for 15 minutes. Ms. Yip, you have the floor for 5.
Thank you, Chair. And I'd like to thank the witnesses for coming today. Mr. Rahami, would you like to finish any comments, as I don't believe you were given an opportunity to answer the questions?
Mr. Chair, no, we can proceed if you have any questions for me. I'm okay.
Okay. So I'll turn to Ms. Hogan, and just picking up on my colleague Ms. Khalid's questions, do you have any expectations with regards to the outcomes of this project review?
You're talking about the recommendation where we ask the foundation to review all of their projects. I expect that they will identify that there are other organizations that were ineligible, and that they would then take those we identified as well as these others and make a decision with Innovation, Science and Economic Development Canada about whether or not any funds need to be recouped, and if not, make that very clear and transparent to Canadians.
Thank you. Mr. Rami, you've taken the top job at STDC after longtime CEO Leah Lawrence resigned amid scrutiny of STDC management and governance. You've been the VP of Investments since 2017. Can you speak to this previous role in the organization?
Yes, Mr. Chair. As VP of Investments, my primary role was to manage the process related to receiving applications, screening those applications, and then for those that would make it through the initial screening, conducting the detailed due diligence process, receiving proposals, detailed due diligence process, and then working with staff to synthesize those recommendations and bringing those forward to the project review committee for a review and for those that passed recommendation ultimately to the board for approval for funding.
In your opening statement, you mentioned that the documents that you have in the government's production order are all documents that departments have. So, in essence, those departments can and should be turning those over as part of the production order. Is that correct?
We have documents from many different entities, but the bulk of what we have in our file is either from the Foundation or Innovation, Science and Economic Development Canada. And so, yes, the Parliament should be receiving government information from the government.
And most of those documents, as I understand it, there's over 10,000 pages that have been redacted, not complying with the order. And ISED is still going through the documents. They've done a couple rounds. I got others. But the order came, as I understand it, from reading the law clerk's letters. The order came from the Privy Council office to say to filter the responses through the Privacy Act and the Access to Information Act, which were not part of the House's order, which is why we're at the stalemate right now, where the government could produce the documents unredacted, because it didn't say redact them or filter them through these acts. They could provide it and get on with the stalemate. So could you tell me who in the Privy, as a recipient, your office as a recipient of that direction from the Privy Council office, who in the Privy Council office wrote that letter?
So I have received absolutely no direction from anyone at the Privy Council office. My desire to comply with the government security policy, which is a requirement of my act, means that I have to go to ISED and say, you own this information. How are you treating it? I think that this dispute between the government and Parliament is one where the government needs to answer for why it is refusing to hand over or redact information. As I used the analogy before, I'm a caboose on this bus. I need to sort of let them go first, then I need to ask them to help me treat the information they gave me in the same way, because it is their information that I'm handing over, not my information.
So they're communicating to you to redact documents in a way that was not part of the House order, I would assume, primarily through ISED and SDTC, who are both on the list from the law clerk as censoring the documents.
So they are not communicating to me. I have been trying to communicate with them to get assistance. As I mentioned, we've had about a dozen conversations. I don't know, Andrew, if you wanted to add more, but it's really up to them to tell us what they're doing to the documents.
Yes, since June, we've had about 12 conversations with ISED officials to figure out the protocol as to how to treat these documents. We will end up getting direction from ISED, but as you mentioned, that's going to be on the basis of the decisions that they have made on those documents.
ISED officials, could you table the list with the committee?
So the main contact is the Chief Executive Audit.
Pardon me?
The Chief Executive Audit.
The Chief Audit.
The Chief Audit Executive, sorry.
Chief Audit for the department.
Yeah, for
Thank
the
you.
department.
You're aware that the Privacy Act, which was cited as a reason to exempt or redact these these documents, Section 8 says that authorized bodies are exempted who have the power to redact documents, Section 8 of the Privacy Act. In fact, I think the Auditor General's Act has a similar provision. It says if you're an authorized body to order documents has that power, they're exempted from the Privacy Act. Are you aware of that?
So I will give Andrew the option if he wants to jump in. So when I received a request from this committee to hand over additional information about the 90 cases of conflicts of interest, I actually had a conversation with the Privacy Commissioner about, I think it's 82M, the clause. It's in the Privacy Act. It is not in the Auditor General Act. And I explored with him what it meant, the will of Parliament, and then it is up to me as the head of the organization to weigh whether the will of Parliament supersedes an individual's right to privacy. That's basically what 82M is asking for. When I looked at most of the information I provided, it is information that you can provide, you can find in the public domain, and hence I provided that table to the committee and cited that letter. But I also felt it important
I'm just short on time.
to tell. I also felt it important to let everyone know that I was handing over that information.
In your opening statement, you acknowledged, as everyone does, the 400-plus year right of Parliament to ask for documents, and if they're unredacted, they're unredacted. That's a long-standing parliamentary right. Is it not true that this whole thing that has frozen the House is related to the fact that the government, the Liberal government, has chosen to ignore the order of the House, which was voted on by a majority of MPs representing a majority of Canadians? 3 parties, not just one party, voted for these
Thank
documents.
you, Mr. Perkins.
Is it not true they could avoid it by just releasing the documents?
I'll allow an answer and move on.
Yes, thank you very much. I think what you're bringing up is the nature of the dispute that's between the government and Parliament. We've characterized it as a dispute. Quite frankly, for us, we feel like we're in the middle of this, but it's really the government that should be accountable for the decisions to redact or refuse to provide documents.
Parliament, thank you very much, Auditor General, for being here with us. I often hear recovery of funds. When I talk to people, is that really realistic? And in one of your recommendations, for example, you suggested that you should review the criteria for admissibility for receiving fundings. But what I can see is how can you decide whether or not a business is eligible for funding? And I don't see how a judge might say, for example, that this is an error to give them funding unless the business had received other documents or explained its eligibility. Perhaps it misrepresented itself to the foundation. How could the government recover any funds in this type of case? Have you identified anything or similar within the foundation? There are legislative measures, but for the government, for the federal government to recover funds, and this is in federal law, the fact that it's a foundation, I think this is a challenge. But first of all, you have to identify who is not eligible and decide what measures could be adopted. And generally there's an agreement, and this is a challenge that the foundation has to deal with. But the agreement between the government and the foundation is that if the foundation provides funding to a business or a client that was not eligible, that money should be recovered. There should be some way to recover the money, and there is that mechanism.
In response to a previous question from Mr. Massey, you were asked about whether there had been any discussions about severance or exit payments for executives. You really didn't answer it, so I'm going to give you one more opportunity. It's a fairly yes or no question. Have there been discussions about severance or exit payments?
Once again, Mr. Chair, as per my previous answer, I'm very focused right now on helping the new board with its transition.
Sir, I'm going to stop you. It's a yes or no question. Have there been discussions, yes or no?
Mr. Chair, that'll be a decision of the board in the future.
No. Under in our system, a refusal to answer can constitute a contempt of Parliament. So I'm going to give you one more opportunity to answer a very simple question. Have there been conversations, yes or no, regarding severance or exit packages for executives at SDTC? It's a yes or no question. You're required to answer.
Mr. Chair, I have clarified the terms of my employment till the end with the new board, and that'll be a question that's better directed to the new board.
So I'm just going to note on...
They decide on my compensation, not me.
Sir, you failed to answer. I'm not going to dwell on the issue, but it's a clear failure to answer a question that was duly put, and it requires a yes or no answer. I want to go to the amended contribution agreement that was signed between SDTC and the Government of Canada. Would it be possible for you to give us a line-by-line analysis of what changes were made between the previous and the current contribution agreement?
Mr. Chair, I believe so. I'll have to look into that, but I believe we can do that.
Okay, I look forward to receiving that. Who within SDTC approved the changes to the updated contribution agreement?
The final approval authority, Mr. Chair, would have been the new board.
So the current three-person board?
That is correct.
Great, thank you for that. I would like to know, were there any projects that were previously ineligible that would now be eligible under the new contribution agreement?
Mr. Chair, with regards to any of those projects that were found ineligible as a part of the OAG sample, as per the recommendation, the new board has put in place a process for reviewing all the projects in her sample period. The review of those particular projects is still in progress, so I don't have anything to report to you at this particular time.
Sorry, I just want to back up on that a little bit, because the question was, with the changes in the contribution agreement, would previously ineligible ones now be eligible based on the changes in the contribution agreement, and vice versa? Those that were eligible, would they now? Are there any that would be now ineligible?
Mr. Chair, I'm unable to answer that question. There are clarifications to the contribution agreement. I am not conducting the eligibility review. The board is directing that process. They're working with independent assessors, and they're committed to getting that process right. The work is ongoing.
So I want to follow up on that, because we keep talking about this process. Now, in this updated contribution agreement, it says very clearly that the foundation agrees to pursue in good faith the recovery of funding for funded projects in such cases, and then it talks about the three types of things. But you keep going back to this ongoing review. Is the foundation, is STC actually making, as required in this document, good faith recovery of that funding? And I don't want to hear this being pushed off. We know that there were a number that were ineligible. So are you making a good faith effort to require the repayment of those funds?
Mr. Chair, the Board of Directors is looking at every project to see if funding can either be resumed, terminated, or recovered. They will take action if and when required, and the work is ongoing.
Not quite getting to the root of the matter, but I think I have time for one final question. Under Section 20.03 and again 20.04, 20.03 requires that the minister be notified and informed about any potential situation that has reasonably interpreted as either a conflict of interest or potential conflict of interest. I'm curious how many times and under what circumstances has the minister been informed of these types of conflicts of interest?
Mr. Chair, I do not recall. I will have to look into that.
Would you be able to provide that information in writing to this committee within the timelines that the chair will lay out?
I will look into that.
Thank you very much. Joining us next online is Mr. Erskine Smith.
Is there any evidence that you came across such that you were concerned there was criminality that should be referred to the RCMP?
In the course of our audit, we did not uncover anything that we felt was potentially criminal in nature. We leave that decision up to the RCMP. We would have referred a matter to them, and we did not in this case. We did talk to them subsequent to our report being made public. And as I previously testified, if they want access to it, that we are happy to comply with the production order.
So you don't have, or do you have any criticisms for how the government has reacted and responded to your recommendations?
Well, I obviously was not pleased that they partially agreed with some of the recommendations, but as I previously stated, I believe that they are implementing what I think is one of the most important ones, which is doing a comprehensive review of all of the organizations that receive funding to make sure that they identify any ineligible recipients.
I didn't think I had to use some of my 5 minutes to educate some Liberal members on your particular role as an Auditor General. You're not criminal investigators. You've never been set up as a criminal investigator. So your ability to detect potential fraud or other acts of criminality in relation to what has transpired under the SDTC is not your mandate. Just like the Ethics Commissioner. If it's blatant, if there's an abundance of evidence, as you've indicated, you can make that referral. But the fact of the matter remains, despite the best efforts of Mr. Erskine Smith, the RCMP have confirmed an ongoing investigation. Whether or not they ask for a production order from your office remains to be seen. But the fact that they haven't doesn't necessarily mean that they won't. And I think that's the message that needs to come through to Canadians watching this. It is an ongoing investigation. They've also confirmed that they've received documents from the House of Commons in relation to the House order, but they've been heavily redacted, which is precisely why government and the House of Commons has come to this gridlock because of government's failure to produce all unredacted documents to the House, which can then be used by the RCMP as they see fit. Whether they look at it or not, that's entirely up to them. But in relation to the potential criminality here, Madam Auditor General, and I want to remind Canadians, we're talking about potential fraud and breach of trust. Fraud is defined in the Criminal Code under Section 380 as follows: everyone who by deceit, falsehood, or other fraudulent means, whether or not it is a false pretense, defrauds the public or any person of any property, money, or valuable security is then guilty of an indictable offense, depending on the value. Redirecting taxpayer funds to the tune of almost $400 million outside of contribution agreements, outside of the law, is in its very nature a fraudulent act. Whether or not the Crown can produce and establish intent remains to be seen. But the police will investigate at a lower standard than the Crown prosecutor who prosecutes potential fraudulent actors in relation to this scam. Let's not forget that the Assistant Deputy Minister, Mr. McConaughey, equated this to simply giving away free money. It was the equivalent of a sponsorship-type scandal. That is how massive this scam, this fraud, this crisis, this issue that is now bogging down the government operations in the House. To ask you one final question. All of this could go away if the government simply complied with the order of the House and released all the documents pursuant to that order. Would you agree with that, Madam Auditor General?
I think, as I've previously said, this dispute between the government and Parliament is one they need to answer for and they need to resolve. I am, complying to the best of my abilities with the order, but ultimately the information resides and is owned by the government.
Simple. This is hypothetical. If the government continues to refuse to release the documents, we have continued deadlock. If the government complies with the order, we can get back to the business of doing government. It's a binary option. It's a binary choice. Would you agree with that? The options the government has? Comply or not comply?
Again, I think that it's up to the government to answer for why they are redacting or treating the information that the way they are.
Right. Okay. Now to Mr. Ramey. Have you been contacted by the RCMP?
Mr. Chair, I have not been contacted by the RCMP.
Has anyone at SDTC been contacted by the RCMP?
Mr. Chair, as far as I'm aware, no one at SDTC has been contacted by the RCMP.
How about the current board members?
Mr. Chair, as far as I'm aware, none of the current board members have been contacted by the RCMP.
Okay. And I think you've indicated this, Auditor General. I want to confirm again, you've had some conversations you've indicated with the RCMP, but they have not directly asked for anything specific. Is that correct? Or asked for any further interviews with you? Is that accurate?
You are correct. We do speak to them on many files, but on this file, we've had regular conversation and we have not received a production order.
Thank you. I'm afraid that is the time, Mr. Rock. Turning now to Ms. Brad.
The RCMP has concluded that the available reports do not identify any criminal offenses or evidence of criminal wrongdoing at this time, whether in relation to any specific individual or organization. He does go on to say that there is significant risk that the motion could be interpreted as a circumvention of normal investigative processes and charter protections. He concludes, I'd like to emphasize as well that the RCMP is operationally independent and strictly adheres to the principle of police independence. In a free and democratic society, this ensures that the government cannot direct or influence the actions of law enforcement, and that law enforcement decisions remain based on the information and evidence available to police. So, Ms. Hogan, the RCMP can request documents and get warrants for the documents it's seeking if it feels that that's appropriate. Why, in your view, is there a need for Parliament to be paralyzed until the government and the OAG releases documentation? Is the RCMP not capable of doing the investigations without the need for political intrusion? Do you have any thoughts on this?
Well, I think it would be, as I mentioned earlier, inappropriate for me to comment on the will of Parliament and the actions that it takes. But my interactions with the RCMP have always been very clear and forthcoming, and they know that we will comply swiftly if they send us a production order.
Thank you very much, Mr. Chair. To the Auditor General, Ms. Hogan, just for the record, to be clear, you're not a lawyer, police investigator, or an expert to determine whether there was a conspiracy to commit fraud or those types of matters, correct?
You're correct. I am a CPA.
Okay, thank you very much for that. And I would submit that further underscores why it's necessary for the government to turn over all of the documents to the RCMP instead of continuing to obstruct Parliament, and instead of trying to use you as a shield to say, well, where was the criminal intent, when you don't look at criminal intent, correct?
Our audit isn't designed to uncover intent or fraud. However, when we do find something that we believe might be potentially fraud or criminal in nature, we would refer that to law enforcement.
I'm going to turn my next set of questions to Mr. Rami. Mr. Rami, with respect to the seed funding stream, it's correct that in order to receive funding under that stream, an applicant needed an accelerator to nominate them, right?
Mr. Chair, in that process, we partnered with over, I believe, 80 accelerators from across the country.
No question that an accelerator would need to nominate them, correct?
That is correct. And
okay.
We would open a round and accelerators would nominate.
So who at SDTC determined the roster of accelerators that would recommend projects under this funding stream?
That funding stream would have, it was our ecosystems team that ran that funding stream and would have reached out across the country to onboard accelerators.
Two of the accelerators that were on that accredited list were Mars and the Vercheron Center, correct?
Mr. Chair, that is correct.
And we know that Annette Vercheron sat on the board of both Mars and the Vercheron Center. Did anyone raise any concerns about this, to your knowledge?
Mr. Chair, not to my knowledge.
So here we have a situation where there are two accelerators connected to Annette Vercheron, and these accelerators get to hand-pick projects to be considered for seed funding, funding that is approved by the SDTC board, the board that Ms. Vercheron was the chair of, and it turns out that eligible expenses under the seed funding stream include the very services that these accelerators provide for a fee. That was the finding of the ethics commissioner in his report with respect to the Vercheron Center. How was that allowed to happen?
Mr. Chair, the report of the ethics commissioner is very clear. I don't have anything to add to his conclusions.
It's a total racket, and again underscores the mismanagement and corruption and conflict at SDTC. To Ms. Hogan, is it correct that in your report you found that it was not assessed by the board or by the department whether the $38.5 million in COVID payments that went out the door complied with the contribution agreements?
The fact that the COVID payments were lumped together and in a bulk approval, I believe they were actually in the consent agenda item, which typically doesn't even have a discussion or conversation at a board meeting. That did not follow the requirements of the contribution agreement. The Parliament clearly laid out that funding should always be provided to an organization on a case-by-case decision, and that was not the case here.
We have $38.5 million that improperly went out the door. Mr. Rami, what steps have been taken by SDTC, the current interim board and interim executive team, to recover $38.5 million tax dollars that improperly went out the door?
Mr. Chair, as I said in the previous round of questioning, the board is currently reviewing all of the eligible projects, including these payments, and they will, as they go through that review process, will then take the appropriate actions that's necessary, whether it's resuming funding, terminating funding.
$38.5 million went improperly out the door, and your answer is that up until now, nothing has been done to recover those funds. That is $38.5 million. What about the $220,000 that went to Annette Vercheron's company in which she was found guilty by the ethics commissioner? I asked a month ago when two interim board members appeared here. They couldn't answer what steps have been taken to recover those monies. Has anything happened since, or has the board continued to be AWOL when it comes to making taxpayers whole?
Mr. Chair, that process is ongoing, and when the board of directors...
Thank you, Mr. Cooper. That is the time. I appreciate it. Thank you all very much. I want to thank Ms. Hogan, your officials from the Auditor General of Canada. Pardon me. You're so right. Ms. Clyde, I even signaled you earlier. Sorry.
I was quite unforgettable,
No,
Chair.
You said it, not me. Ms. Clyde, you have the floor 5 minutes, and I apologize. It seems Ms. Blaney's going to think I do this as a matter of course, all witnesses. Ms. Clyde, you have the floor.
Thank you. I don't have a lot of questions, but I do want to clarify some points. Ms. Hogan, does being a police officer or an agent of the court, rather than being a CPA, would that help you in furthering your duties and obligations as the Attorney General? The Auditor General, my apologies.
I'm often called the Attorney General, but yeah, the Auditor General. So my mandate is very broad. I have very broad access, but I am not here to determine intent. That is a criminal matter, and that I would leave to the experts who are the law enforcement.
And I just want to say, having a CPA is no easy feat. So I appreciate all the expertise you bring to the Office of the Auditor General. So thank you for your contributions. Now I just want to go back to Mr. Rami, if that's okay. Now we're talking about the the whole sector of clean technology and the impact that freezing of funds has had on that sector. Can you talk to us a little bit about what the industry and the sector is saying with respect to having their funds frozen funding for the past year?
Yeah, Mr. Chair, I know that this is in the current economic environment. Liquidity has certainly been an issue for companies, small and medium-sized enterprises operating in innovation space, not just in the clean sector, but sort of across the board. And certainly, the freezing of our funding has had an impact on companies that have existing project funding agreements who have met all the eligibility criteria. In some cases, they've had to slow down their work or take other actions. And we've heard a lot from companies who aren't able to access this funding to be new applicants to help them launch their new developments as well. Again, whether it's been a slowdown, et cetera.
Thank you for that. And lastly, I'll ask Ms. Hogan. Can you help us understand and clarify why independence of your office is so important in terms of how you function with Parliament, with government, and then fulfilling your role as the Auditor General as well?
I think having an independent Office of the Auditor General is a cornerstone to good democratic system. You know that you can rely that the information I provide is free of influence, that it is based on fact, and that also requires us to have clear access to information so that we can provide factually based information to support Parliament in holding the government to account. So as soon as you impede that, it potentially either reduces the importance of our organization or impedes our ability to continue to provide fact-based information to Parliament.
And do you think that your office's independence is right now being impeded by the activities of Parliament, especially in relation to this production order in the House?
As I've said, the dispute that's going on between Parliament and the government is one for the government to resolve. I respect the will of Parliament, and I am trying to comply within the parameters of my act, which means that I have to allow the owner of the information to tell me how I should treat it before I can hand it over.
Thank you very much for being here today. Appreciate that. Thanks, Chair.
Thank you. And again, I apologize about Ms. Khalid.